This lecture is entitled Change is a-Comin', Maybe. And what I want to talk with you about during this lecture is the amendment process to the Constitution. So there are 27 amendments to our Constitution. And if that number seems small, it's not surprising. The amendment process laid out in Article 5 of the Constitution is a very, very high bar to pass. 3/4 of state legislatures need to approve an amendment that is the product either of Congress or a national convention. That is an option that we have that we've never utilized. Our 27 amendments have come from proposals either from the states or from Congress. The amendment process then, because it requires 3/4 approval from the states, is what we call a supermajoritarian rather than a majoritarian process. And because of this, many amendments never see the light of day. Every Congress that goes by every year sees lots and lots of amendments put forward, but they never pass. Similarly, every single Congress that goes by sees many amendments initiated from the state level for congressional approval that never, ever see the light of day. Like with much legislation that never lives or never comes into being, amendments very, very rarely, indeed only 27 times. And if we factor in amendments that repealed other amendments that came before it, that number is even smaller. But nevertheless, there are some important and really interesting facts about the amendment process that we should take into consideration. Originally, and this is really interesting considering the fact that the amendment process is so difficult, the founders actually thought that this process, requiring the supermajoritarian amount of votes to pass an amendment, was actually more democratic than we had seen so far. We have to remember that America's first Constitution was the Articles of Confederation. And for over a decade, that was our governing document. But to amend that document, you needed unanimous approval of the states. So reducing that bar to 3/4 from 100% approval was, in the minds of the founders, a very democratic move and a way, in their minds, to make the amendment process easier. The other really interesting thing about amendments is that while there are 27 of them, they weren't all passed at the same time, as you can imagine. In fact, most amendments were passed in clusters at identifiable periods in American history. We can learn something from that as well. What we know of as the Bill of Rights, the first 10 amendments to the Constitution, were actually one of two things that the very first Congress did. The very first Congress, the first Congress. One of the two things they did was set up a court system, as Professor Robertson said yesterday. The other thing they did, though, was pass the Bill of Rights, or vote on the Bill of Rights, and 3/4 of the states immediately approved, and those became the first 10 amendments to the Constitution. And not very long after the Bill of Rights was passed, in this identifiable period of American political history, the 11th and 12th Amendments were passed. The 11th Amendment provided that states, gave states what we call state sovereign immunity, so citizens of one state cannot sue another state under many circumstances. And the 12th Amendment to the Constitution came not soon after that, which amended the Electoral College process, which will be a subject of another IACH podcast very soon. And we didn't see any amendments, really, from the founders' own generation up until the end of the Civil War, when we see a new cluster of amendments. These are what we call the Civil War, Reconstruction Amendments, the 13th, 14th, and 15th Amendments, all in reaction to the terrible turmoil of the Civil War. The 13th, of course, makes slavery unconstitutional. The 14th Amendment does lots of things, including making people citizens. And as we said in another podcast, it also created new requirements, or new prohibitions, I should say, new prohibitions against states, saying that states cannot deny you your privileges or immunities, states cannot deny you the equal protection of the law, and states cannot take away your life, liberty, or property without due process of law. We also saw clusters of amendments during the progressive or populist movement in the United States, dealing with voting and dealing with actually changing the way we vote for senators. It was in 1913 that the 17th Amendment was passed that provided for direct election of senators. Up until 1913 in the United States, we did not directly elect our senators. Our senators were chosen by our state legislative bodies. And we also saw a cluster of amendments in the 1960s dealing with voting, specifically in reaction to two significant things in the South of the United States. One was racial discrimination in voting, and the other was this increasing divide in the United States between rural and urban voters. So the Constitution was amended to provide or to make sure that changing demographics and changing notions of racial equality were things that were protected in the franchise in voting. Another interesting fact about the amendment, there's only one amendment, the 18th, which has been repealed by a subsequent amendment. Of course, the 18th Amendment outlawed drinking, and the 21st Amendment repealed the 18th Amendment. So that's the only amendment that is an amendment that is not saying anything positive in the sense, not putting some kind of idea forward or changing some kind of process or creating a new kind of governmental process. It's simply there to repeal an earlier amendment, and I would certainly raise a metaphorical glass to the 21st Amendment. But here, that's a very interesting amendment, and it actually reduces the amount of substantive amendments to the Constitution to 26 then, right? So there's even fewer than 27 amendments in terms of an amendment that puts some substantive idea forward or amends a process or creates a new kind of political process. But there's something else I think we can see here with prohibition in the 18th Amendment and then its repeal in the 21st Amendment. And that's that with the exception of the 18th Amendment, which prohibited alcohol, all of the other amendments, for the most part, are procedural amendments. They deal with procedural issues. We're going to change the way the Electoral College works in the 12th Amendment, for example, so we don't make two votes on Election Day for president and vice president. We vote for one ticket, for example. That's a procedural amendment, right? The amendment that says that you only have to be 18, or those 18 and older can vote. That's a procedural amendment. But prohibition was a moral amendment. And some scholars, including myself, argue that that's maybe not the best thing for amendments. Now, we only have in social science what we call an N of 1. We only have one case to evaluate this argument. But in the case of an amendment that had a moral kind of intonation to it, right? There's something morally wrong with the consumption of alcohol. That's the only one that has been repealed. So that's some food for thought with respect to the amendment process. Another interesting fact about amendments, there is one amendment that could never be passed. There is one amendment. We could have an amendment that said we all have to wear red shirts. Now, that might sound crazy, but we could have one. But there is one thing that the Constitution says that we could not do through an amendment, and that is decrease the representation that each state has in the Senate. Every state is equal in half of our legislative branch in the Senate. No matter how big California gets population-wise, it only gets 2 senators. No matter how small North Dakota gets population-wise, it will always have 2 senators. So we could, in a sense, say that there would be, or can be, an unconstitutional constitutional amendment. And that would be an amendment that sought to change the equal representation of states in the Senate. But that wasn't the only time that there could have been an unconstitutional constitutional amendment. The Constitution provides that the slave trade could not be reduced or put out of business in the United States until 1808. It doesn't actually use the word slaves. It talks about the trade or migration of persons. But it means slavery. And the Constitution explicitly says that we cannot pass a constitutional amendment before 1808 that prevented that trade or stopped it altogether. So we have had, or you can imagine that there could have been 2 unconstitutional constitutional amendments. One is moot now, not only because the Constitution said we could pass an amendment after 1808 or regular legislation to end the slave trade, which we did, but also because the 13th Amendment now prohibits slavery. But there is still one amendment that we could never pass, right? One unconstitutional amendment, and that would be the reduction of the amount of senators or representation at all for states in the Senate. So other than these interesting factoids, which I hope are more interesting than kind of navel-gazing about the Constitution, what can we learn about the amendment process? Well, like so many other clauses in the Constitution, almost every one of them, but especially the ones that seem arcane and difficult to understand, there are still important lessons that we can garner from the amendment process, just like there are important lessons that we can garner from other seemingly difficult amendments. As I've talked about before in other lectures, but I'll explain again now, the Constitution was understood by the framers as a higher law, the kind of rules of the game that structure the political world where ordinary politics happens. So we have ordinary politics every day that is dictated to and controlled by this higher law. Ordinary legislation, ordinary executive decisions, ordinary judicial decisions, ordinary agency decisions throughout government on both the national and state level are happening every day. But sometimes we have to ask whether they run afoul of some kind of rule. The Constitution is that. It's the higher law. It is the rules of the game. Right? Now, if we understand that to be the case, and because the rules of the game can trump any kind of ordinary legislation, if that ordinary legislation or executive action runs afoul of the rules of the game, we have to understand that it's a very important notion, right? Almost a sacred kind of law that shouldn't be easily changed. And despite the fact that the framers thought that by changing the amendment process from the Articles of Confederation from 100% unanimous ratification to 75% or 3/4, they still, and Madison says this many times, thought that the amendment process was an awesome process. In other words, it was such an important process that it shouldn't be easy. Ordinary legislation is easy relative to the amendment process. Ordinary legislation simply is a majority vote, right? 50.1%. That's sometimes easy, and more often than not, easy to get. But changing the higher law, changing the rules of the game, should be something that does have a high bar to it. After all, it is a higher law. Thank you.
Freedom 101 is made possible by generous support from Woody Young and the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.